For the appellant? Yes, sir. Yes, sir. Go right ahead.
Good morning.
For the appellant, are you prepared? Go right ahead. The appellant?
Yes.
Oh, on this side.
I'm sorry.
I think
I
maybe
did not hear you
Yeah.
we
clearly.
switch sides there.
Oh, we did?
Yeah.
I apologize.
Is there a sign that says where you're
There is-
supposed to be?
There is a sign. We both did.
Sorry about the confusion,
No
Your Honor.
problem.
May it please the court, I am Noble Grant with the Jackson-Madison County Bar Association, and I represent Mr. Robert Cali, the appellant in this matter. This appeal stems from a divorce in Madison County Chancery Court, and and before I begin, I'd like to reserve 3 minutes for rebuttal.
Go right ahead.
There's a lot to unpack with this case, and I'm not going to attempt to do so in 15 minutes. So I would like to touch on some of the issues I feel are, I guess, need more of an explanation. The facts in this case were about as difficult a set of facts as a parent or a party to a divorce can imagine. The parties in this case found out while the divorce was pending that their daughter, who I believe was 2 at the time, if I'm not mistaken, was diagnosed with a form of terminal cancer. The parties had already been through a cancer diagnosis with their older son years prior to the divorce, so as you can imagine, emotions were quite a bit out of the ordinary, and it was just a difficult situation for everyone involved. In any event, the parties were unable to reach an agreement in the divorce matter, and it was tried over the course of 2 days. There had been a substantial amount of litigation prior to arriving at the divorce trial, some of which I was involved with, and some of which I was not, predated my involvement. But I would like to point out that we tried this case over the course of 2 days, dealing with the set of facts that we were dealing with. And while I have much respect for the trial court, after the conclusion of the proof and arguments, the trial court jumped immediately into its decision. And I point that out because I wish that maybe we had taken a break to reflect on the proof and taken a break to let things process before we immediately jump into a ruling on a case with the set of facts that we were dealing with here. That's not what happened, though, and as a result, I feel like the trial court, its order is deficient in some important areas, and that the trial court erred in some very important areas. First of all, I guess I'll touch on this one first because it's first raised in my brief, but there were really no findings in regard to the factors enumerated in 36-4-121 as far as dividing marital property. And I don't believe that the findings are sufficient pursuant to Rule 52. There was actually no analysis of those factors found in the trial court's decision, and as a result, this court, I believe, might find it difficult to try and figure out what the trial court was thinking at the time it made its decision. That also led to an inequitable division of the marital property, a division which resulted in, I believe, about an award of about, I think, 29% of the marital estate to Mr. Cali, and about 71% of the marital estate to Ms. Cali, which we would submit is inequitable, and that decision should be corrected and made more equitable. There was a home at issue, and what we're proposing would be that the entirety of the equity in that home, the home was awarded to my client, Mr. Cali, but we propose that the entirety of the equity in the home be awarded to Mr. Cali, which would correct that inequitableness on that issue.
What would be the breakdown if we were to do that?
If you were to do that, so Mr. Cali ended up being awarded well, the trial court found the value of the home to be $160,000. The debt on the home I don't have that information in front of me at this moment, Your Honor, but I do believe that when I ran the numbers, that the equity, if it were awarded to Mr. Cali, would make it, I want to say in the range of 48% to him and 52% to Ms. Cali.
Okay.
You seem particularly critical of the trial court having ruled immediately from the bench, but there were additional findings made by the trial court as to being voluntarily underemployed and other things like that when he made that award regarding the equity in the home. Is that correct?
That is correct. Yes, there was a finding that that Mr. Cali was voluntarily underemployed, and probably I would submit a more important argument to address in my brief. There weren't many findings about that, and I don't believe, I mean, the law is the trial courts to look at the reasons for voluntary underemployment, and if those reasons are reasonable, if the parent's reasons for not being employed are reasonable and in good faith, then a voluntary underemployment finding should not be made. Mr. Cali at the time was seeking more hours, but he was also employed by a company that was very understanding of his situation and was working with him on a very flexible schedule. And
He didn't seek any employment anywhere else, right?
he didn't, not during the divorce, the pendency of the divorce. The party's daughter had many medical appointments during this time. That
Well, actually,
Mr.
they
Cali,
both took a leave of absence, correct? So that they
under
were able to do that?
FMLA, they or at least Mr. Cali did under the Family Medical Leave Act. They both took a leave of absence, and I think Ms. Cali went back to work. Mr. Cali somewhat went back to work. But again, wanted to make himself available for Salah's many appointments that he was not able to attend during his son's cancer diagnosis and treatment years prior. He made a covenant with himself that he was not going to let that happen again. And so I think that his reasons for keeping his work schedule flexible were reasonable and made in good faith. And I don't believe that a finding of voluntary underemployment was appropriate in this matter. Importantly, the court failed to maximize Mr. Cali's participation in the lives of the party's children. Now, I've cited a case, N. Ray Lennon, and it's a case where this court found that the trial court had done this very thing and not maximized the mother in that case, her participation in the life of the party's child. There was a guardian ad litem involved in this case, and the guardian ad litem's opinion on this, I believe, he was tasked with representing these children and advocating for these children's best interest. And the guardian ad litem found that this was more of a conflict between the parties, the parents, not a case of poor parenting skills, and even specifically said he didn't feel like the conflict spilled over into the parties' parenting skills, the conflict between the parents. Notwithstanding, the trial court's order severely limits Mr. Cali's parenting time. It amounts to basically in every other weekend schedule. Mr. Cali gets a little bit of midweek time and a little bit more time in the summer, but these parties live within miles of each other. It's not like they live a great distance. There was no reason. The complaints about Mr. Cali didn't have have anything to do with his abilities as a parent and his performance as a father. They had to do more with some of his behaviors during some of his behaviors toward Miss Cali during a very extremely stressful time in these parties' lives. And I do not believe that there was evidence sufficient to limit Mr. Cali's parenting time to the amount of time that he was awarded by the trial court. And I feel like the trial court did fail to maximize his participation in the lives of the children. So we're asking that this matter be reversed for sufficient findings and to correct errors that we have alleged in our brief. And as to the other issues, unless there are any questions, I would stand on my brief in regard to those issues.
Let me ask you, what happened on the issue of retroactive child support?
Retroactive child support, that was, I believe, addressed in a motion to alter or amend, and there was a decision on retroactive child support. If I'm not mistaken, I believe the issue may have been waived. I'm not positive about that, though. That is not a portion of the record that I reviewed in preparation for this, but it was addressed in a post-trial motion, and there was a decision made on that.
Okay. And that was before the appeal was filed?
That was before the appeal was filed, correct.
Okay, all right.
Okay, you have your rebuttal time.
Good morning, Your Honors. I'm Jennifer McEwen. I'm from the Gibson County Bar, and I'm here on behalf of the Appellee. I guess I will start, if I can, as Mr. Grant did, and say that I want to acknowledge the fact that this case had devastating facts. It really did. It was hard for the court, it was hard for the attorneys, it was hard for the parties. However, I would ask you to not let that take away from the fact that most all of the hearings circled around and focused on the condition, the medical condition and behaviors of the father and how that impacted his parenting time and how that impacted their co-parenting abilities and his ability to manage even his own self and to work. And so I would ask, even though that we did have a death of a child in this case, that we focus on what the main issue as to the father's inability to parent based on his medical condition. Your Honors, too, I would like to address a couple questions that you asked counsel regarding retroactive support. There was a flub in this case. In fact, in the very beginning, we handled retroactive support. It was in an order. The mother got a judgment. I believe it was a little bit over $5,000. It was in one of the very first orders, and if my recollection is correct, it was from a hearing in the summer of 2022. What happened after that, counsel came in after that, and what happened after that is, I think, truthfully, I think we forgot. And so then it came up to be a question that we didn't address at trial, and so then we had to get that issue determined so we could have a final judgment. And then we did at that time, my client and I did agree and stipulate that we would waive it. However, it was already determined. So that's what happened to that. As to the breakdown, and this is my calculation, and you would never believe that I have 2 degrees related to math because I'm not great at math, but based on my calculations, that it would actually be on the division, if you awarded all of the equity to the father in that question, it would turn out to be 33% to the wife and 67% to the husband, and that would actually just be basically a reversal of what we have. And one of the points in my brief was that if it's not equitable, but just because of the numeric disparity at 69% and 31%, then how in the world is it any different at 33% and 67%? And on that note, the appellant did not submit any facts that would preponderate against the trial court's ruling. It just alleged that it was just inequitable. I am reminded of a case that I did not cite, of the Palaconda case, and although I did read it and it did seem to appear that the appellant did waive the issue of that, it was a 70-30 split from my understanding, and although she did waive the issue at the day of the oral argument, or at least on the appeal, that was undisturbed. And so that has been that is now affirmed and is in a 70-30 split, and it really doesn't have to do with the number, Your Honors. It has to do with whether or not it's equitable.
You say you did not cite this in your brief?
I did not, Your Honor.
Do you want us to consider the case?
Your Honor, when I read it this morning, one of the attorneys who was on that informed me of that, and when I read it this morning, because it looked like the issue of the division of marital property was waived, and that's why it was affirmed, I didn't print it.
Well,
But
the point is, if you want us to consider it, you need to send a copy of, well, not a copy of the case, but the citation and a copy of the case, yes, to the clerk's office to be presented to us without any argument.
Yes,
that
Your
if you want us to consider it.
okay, thank you, Your Honor. I'll just start from the beginning of the way that the appellant has listed the issues, and Your Honors had mentioned that he had discussed whether or not the court actually complied with Rule 52.01 and made all the required factual findings and drew all the conclusions of law that it needed to. And in my brief, I stated the answer to that is yes. I think the problem, it's not really a problem, it's just a complicating factor, was that there were a number of stipulations that occurred regarding the division of marital property at the beginning of this case. And there were stipulations that kind of happened as admission by the parties throughout the testimony. And so when you're looking, they didn't have a lot of property, but they did have some, and they certainly didn't have a lot of debt. So when you're looking at the different accounts, generally everything was stipulated to, and in fact, I believe that's the court's words were much was agreed to, and the court did accept those stipulations and put that into their columns in the balance sheet and in the consideration. But only about 4 things were left, from what I can tell, and that was the Honda Odyssey, and really it was not who was going to get it, it was about whether or not it was marital or separate, and the valuation of that. And then the wife savings account, where, and that was really an argument on our behalf, that it was not marital, that it was separate. And of course, the court concluded that it was marital after looking at the factors that it did. The house was the big issue, the valuation of it, and the court did pick a valuation in between the two parties. I think one was $112,000 on behalf of the appellant, or the husband, and the mother's was about $200,000, and so they did choose a value in between. And then the equity division. And of course, you've heard about that, but the other fourth, the other fourth issue was the actual debt owed, or alleged debt owed to the parents, that was incurred because the husband chose to stop working. He chose to stop working, and he intentionally did this. And Appellant has even admitted to some of this in his argument, that he did not seek other employment. So the expenses that form the basis, at least of a lot or more of this entire $57,000 amount, was because he wasn't working. So he was having to pay expenses for himself, to see his children, and those are things that, at least in part, maybe he needed help with his attorney's fees, maybe he didn't, but at least in part he could have offset some of that, but it was his conduct that did that. And so when the court looked through and did consider these four contested issues, as to the Honda Odyssey, the court specifically looked at who purchased it, when it was purchased, the funds that were used to purchase it, whether those funds were commingled, which they were, and then the vehicle's use after the benefit, the vehicle's use after the purchase, and it was to benefit the household. So the court determined it to be marital, gave it a value, and it did allocate it to the wife, and I believe, Your Honors, that it was already agreed that it would go to the wife, that the husband would get the Civic and she would get the Odyssey. The wife savings account, those funds, the court easily determined that those were marital based on the definition of marital and separate property, and did put that in the wife's column, consistent with the parties' agreement as to all of those accounts. The wife was going to get hers and the husband was going to get hers. This even applied to the retirements that were not disputed and were stipulated to. Again, the house, the court determined the value of it, and then it actually split that equity. It split the equity and said, this is what I'm going to do. Up until this point, we're at a 52-48 split. 52% in favor of the wife, 48% to the husband. And if we left it right here, that's where it would be. And the court said that's equitable if that's all we have. But that's not what we had. We had a claimed debt owed to the parents, and $57,315. And so the court it actually went through all the factors. Factor one, in looking to determine whether or not, or how it should be allocated. Factor one wasn't relevant, wasn't mentioned. Factor two, the earning capacity was discussed, and I have the cites for that. Factor four, the relative ability of future acquisitions and assets, indicating the wife was actually more able to pay the debt and had more earning capacity. The contributions of each party, noting that he did not work, and that, in effect, contributed, again, as I just said, to this debt, and that was a conscious choice. It is noteworthy to mention that this case started in 21. After the diagnosis on March 17th of 2022, he takes a leave of absence. He does not rejoin the workforce. The court had in its, as one of the exhibits, the Social Security statement showing all of the earnings, and you can see clearly on that, I believe it was Exhibit 40, and I can pull that number, but it did show that he did stop working. The court ruled that he was voluntarily underemployed in the summer of 2022, and gave him basically a year, and he didn't correct that behavior at all. And he received less and less parenting time based on his actions and his respectfully deficiencies because of his extreme obsessive compulsive disorder that did, in fact, it wasn't just emotions in the case. It was his impairment that, unfortunately, when triggered by stress or any other thing, that it would severely impact his interpersonal skills, and his behavior in the courtroom, his behavior outside of the courtroom, his behavior in front of the children. And so that did impact that. Factor 6, back to this, it was, the court apparently did not think it was relevant, and I'm not wondering about that, they just didn't think it was relevant. The parties just really didn't have any separate property to value. The only thing that was divided that was non-marital was the 529 account of Isaiah, the son, and that was just not marital. And not separate. The parties didn't have any money when they came into the marriage, respectfully, so Factor 7 was a non-issue. Factor 8, the court did consider the economic circumstances of the parties at the division, and discussed again that the father was just not gainfully employed, noting that the mother, throughout this, her daughter, she was the primary caretaker, she was working. She worked through all of it. Her average income was somewhere around $5,000, a little bit more than that when they calculated it for child support. She worked on the days that she did not have the child. She was able to. Why didn't the husband? Why wasn't he able to? He couldn't say. He couldn't give a reason, other than I think he said he was keeping his house and making it a home. There were no Factor 10, there was no closely held business. Factor 9, there were no tax benefits or considerations to make. Number 11, there was no Social Security benefits except for SALAs, and that really wasn't a consideration. There were none for the parents. And then Factor 12, the other factors the court could consider as they felt that they were necessary to make sure that the equities were the same. Again, the court mentioned it throughout, and I'm not trying to be redundant. It's just the fact that he didn't work, and that's the reason that we have the loan, if in fact it was a loan at all. And the court did struggle with whether or not it was a loan. Factor 13, the court looked at the amount of the litigation expenses, and the court did rule that all the litigation expenses, attorney's fees and otherwise in this case, were reasonable under the circumstances. Ultimately, the court did award that to the husband or charge that to the husband, and then to offset it, because the court noted that if he left it alone, it would not be equitable. They did offset it by $10,000. And so call it an equalization payment, call it a portion of that debt that was attributable to the wife, but we did, and that's where we get our split. And I see that I'm running out of time, so I'm going to go and, I will say, Your Honor, if you look at, in the event that the court finds that the court could have done a better, trial court could have done a better job in making factual findings and conclusions of law under, is it Terman? I hope I say that correctly. And I can submit this. The court says that even in the absence thereof, the appellate court may, quote, soldier on when the case involves either only a clear legal issue or when the court's decision is readily ascertainable. So the court may soldier on. So we don't have to just invalidate or vacate the entire thing. We can soldier on if you can tell reasonably that what the court was doing and why they did it. Looking at, I'm going to jump straight to the maximization of and custody factors and maximizing the parenting time. I want to note that I counted, and hopefully this is correct, it looks like since the beginning of this case we have had 8 visitation-related orders. And in my history of 20 years, I don't know that we've ever had a case that ever had 8. The court listened to this and listened to it and thought about all of the considerations and the behaviors. And it started in 2022, it started at 50-50 time under an ex parte order that the husband got, alleging that he would be denied parenting time when she left the hospital at St. Jude. So we started at 50-50. But then even on the off weeks, the court granted, after that hearing, I apologize, I misspoke, 50-50 time in the beginning. We get to the hearing 2 or 3 weeks later, it goes down to mom having 5 days, dad having 2 days, and the court says, Dad, you can still go visit every single day that you don't have the child. Both parents can still go visit. And then at the next hearing, with the photos of the strapped-on recording device, with all of the things that happened, just every single time this occurred, the court ordered found that was an abysmal failure. I believe that was his words. And so, again, we had to reduce parenting time. And then every single time, we have to reduce parenting time. There were a couple of times that the court said, okay, we're going to alter it in favor of the husband, but again, it did result in the parenting plan that we ultimately have today. And there was testimony at trial by the mother that said, finally, after all of these restrictions and after all of these attempts, and these are my words, not hers, she did say we have finally stabilized and we're starting to find some peace. And so with his condition and with the way that his behavior affected every single thing, it made him unable to be a primary parent or a half-time parent. And this truly was a maximization of what the court could do with what they had to work with. And in closing, I'm about to run out of time. Again, I would ask you to soldier on where you think that the court is deficient in its findings. I want to point out that in all these arguments, that the appellant did not point to any certain facts that would go against the finding of the court. The appellant just said that it just was not right. And so I would ask that you affirm this decision in full, and that when appropriate, costs be awarded and potentially attorney's fees be awarded unto the appellee. Thank you.
Thank you. Yes, sir, your rebuttal.
Thank you. I took a moment to review the record. The retroactive child support that Ms. McEwen just mentioned in her argument was an interlocutory order that awarded mother a retroactive child support judgment while the case was pending. In Volume 4, page 497, there was an order entered from a hearing on a motion to alter or amend, and it addressed the final judgment in regard to retroactive child support, and it was waived by mother due to an overpayment by father. So father, I think, had actually overpaid by about $800 some odd at that time, and so that issue was waived at that time pursuant to that order. My math, when I originally addressed the issue on the division of property, my math appears to have possibly been somewhat incorrect. The trial court, the total equity of the marital estate was $117,756 as found by the trial court. The trial court awarded husband $36,302 of that, $61,136 of which was his award in the equity of the marital home. Wife was awarded $81,454 of the marital estate, of which $41,135 was for her portion of the equity in the marital home. That was for that $10,000 offset that Ms. McEwen mentioned. An equal division, split right down the middle, would be $58,878 to each party. We're asking that the court make an equitable division. That's what we're asking. That might not mean awarding Mr. Cali all of the equity in the marital home, but awarding him more than what amounts to roughly 30% of the marital estate. We don't feel that that is equitable. And lastly, I didn't touch on attorney fees, but Mr. Cali has what we believe to be arguments that could be successful on appeal. He's brought this appeal in good faith. We do believe that the trial court made some errors in this matter that could very well be reversible errors. We think that they are reversible errors. This is certainly not a frivolous appeal or one that has been brought in bad faith. So would ask that Ms. Cali's request for attorney fees be denied.
Thank you, sir.
Thank you.
I want to thank both of the parties for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and ruling within a